everyone. Thank you for being here. This is our Q&A on pro bono custody cases. My name is Susan Blissett. I am a legal services coordinator at VIP. Here we also have Denise Lynch, our supervising attorney, and Cassie Gruber-Bartooth. She is our pro bono case manager that also handles a lot of family law cases. Today we're going to be doing a Q&A based on questions that volunteers might have before they embark on their first of hopefully many custody cases with VIP. I'm first going to introduce our speakers, and then after that, we'll jump into a couple questions that we've drafted for the Q&A. If anyone has additional questions, please don't hesitate to let us know, raise a hand. You can also drop them in the chat if that's easier for you. Cassidy is going to be monitoring that throughout the Q&A. So first, we have Lise Fisher. She is the owner and attorney of her firm, Fisher Family Law. Thank you for being with us. Next, we have Lee Schwartz. He is a partner at Schwartz, Fox, and Saltzman LLC. They also do a lot of family law work. And then finally, we have Ms. Sarah Katz. She is an associate clinical professor of family law at Temple Law, and she teaches and runs the family law litigation clinic at Temple. So if everyone is ready, we'll hop in with the first question. And for our volunteers that are here, you can feel free to answer however you feel fit. If all of you want to answer the question, that's also fine. So the first question we thought of is, how much prior custody experience does a volunteer need to take a custody case with VIP?
Who's going first?
Jump in and say none. I mean, I think the wonderful thing about VIP volunteering is that we support the volunteers so much. And so if you're nervous about jumping in and taking a custody case, that's what all of us are here for. I think each of us mentor folks in cases if it's your first time doing it. And I feel very confident in saying that VIP volunteers can do this because I send 2L and 3L law students into court who've never done a custody case and, get up to speed and are able to very confidently handle those matters, as students in my law school. So certainly barred attorneys out there in the world can get up to speed and jump in and do it.
Yeah, I don't think I agree, absolutely. And get a mentor through VIP. I think what you do need is just, organization and wanting to learn and the ability to ask questions and recognize what you don't know and ask a mentor, ask VIP, ask another family law attorney. And that's how you're going to build the experience. I don't think everybody has to start somewhere. So.
Those were great responses. Our next question is, what does the average timeline of a custody case look like from start to finish once you receive the case file?
I think the simple answer is I wish I knew. It's if you can resolve it in front of the custody officer, which is the first step in the process, you can have a custody case done in 6 or 8 weeks after you filed it, because you can walk out with an agreement or with a recommendation that both parties agree with. If you're going to go in front of a judge, then you're looking at many months, and things have a way of getting continued and postponed and relisted and all these things, and it could well be over a year. So it's a whole different can of worms in front of the judge.
I do want to say that we do want to frame these in the context of VIP, where more often than not, we do ask volunteers to take these cases, but we aren't expecting them to stay on the case for the life of the case. We're more often that they may only show up for the initial representation, initial date, if they have that capacity. So we tailored the answer a little bit that way to maybe a case you're taking for VIP and how long you think it's taken, and that framework would be helpful.
Well, if you're only going to stay in through the custody officer's event, then it can be 8 weeks. You'll be in and out.
And also if you take one that's longer, so if somebody else stays in or you decide you want to stay in to a hearing, there's also, I mean, the process may take a long time, but the hearings are, I mean, they're actually coming up a little bit quicker now, but the hearing could come up anywhere from 2 to 6 months later, but you're not spending all that time working on the case. And sometimes it's an advantage, especially if you're new to it, because it lets you use that time, you know, to learn and ask questions and to prepare at your own pace. So it does take a long time sometimes, but you can use that time and it's not like you're working the entire time just on this custody case.
Right, those are great responses, and they actually piggyback off of two additional questions that I had. So the first one was, on average, how many hours do you think you spend on a single custody case? I know it varies situation to situation, but I think a concern can be for new volunteers, how much time am I going to be spending on this in conjunction with my day-to-day work?
I think it's a really hard question to put an exact number to, because some cases are really complex and some cases, you know, are not. Some of it may depend upon how you've limited your representation. So for example, if you're getting into the case only to prepare for an upcoming trial and handle that trial, and then you're coming out regardless of what happens, like, you can really tailor your hours around that. I think the one thing about custody cases in particular is they do involve quite a bit of client counseling as well. So while that's not, you know, hours and hours, it may be, you know, quick check-ins with the client, like, hey, this has happened, now what do I do? Or, you know, this issue has come up. And sometimes that can give rise to other filings and things like that, or the need for other filings. But there is, you know, I feel like I spend a small amount of time kind of touching base on cases throughout the life of them while we're waiting those months for preparing for trial, with then like a flurry of activity around, you know, if we're preparing for trial.
And it also depends on the relief being requested. So if your client or whichever side really just wants partial physical custody, you're going to spend a lot less time than you will if it's like a relocation case or primary custody. So that's part of it. It's also how detail oriented you are and how much time you want to spend on the case. And I absolutely agree with Sarah. A lot of time is just client management. So you can have some clients that get it. That's going to be less time than a client, frankly, that doesn't. So yeah, there's a lot of factors that go into it. You can sort of tell that at the beginning. And again, if you have a mentor or somebody else that you talk to, I like to get organized at the beginning, and I do like a schedule, even if it's a couple months, just on a legal pad of this is what I want to get done in this period of time. And I think that organization helps and helps me spend less time on the case.
Great, those are awesome responses. Going in the same direction, we spoke a little bit about people being concerned that they're going to be representing a client through any and all custody or family law matters that could come up in the future. Do you find that after you've wrapped things up, you withdraw your appearance from a case, you know, once things have settled and an order has been granted that the client is happy with? I think a big concern is volunteers who are not used to this are worried that they're going to be, that an appeal might come up or someone wants to modify an order in 2 years and they're still going to be the attorney of record on the case.
Well, that's up to the attorney. Certainly you can terminate your representation at the end of whatever your involvement is. What you're going to find, and what I find, I'm sure Sarah does and so does Lise, is that if people are happy with your representation, they're going to contact you directly for the next event. And they're going to say, hey, can you help me? And if you're softies like Lise, Sarah, and I are, you're going to say yes. Or they're going to contact, you've done a custody case and then there's a support issue, or there's a custody case and then there's, but it's up to the lawyer. You don't have to. Your representation ends when you want it to end.
Yeah.
So it's that fear that you're going to be kind of dragged into this multi-claim abyss is really up to you to decide how involved you want to get into other matters.
What I do as a matter of practice is I always withdraw my appearance at the conclusion of any set of litigation. So whatever petition was pending, once that's done, I withdraw my appearance, because that way I get a choice whether I'm taking the client back and the situation back. It may be the client you liked the best, but a couple of years down the road, they're contacting you and they're completely in contempt of the order and you're not interested in taking on the case, or, something like that. I mean, I find it allows me to make a decision. So if I make my practice, hey, I'm going to terminate representation at this point, and should an issue arise in the future, contact me back. But that way I have there's a very clear delineation, and then the ability to say yes or no if they come back. And so, yes, sometimes there are repeat flyers and people who come back, and yes, I'm a softie and often will say yes, but there are also folks who will come back. I mean, maybe the dynamic is a little bit different because my office provides pro bono legal services as well, but I'll even have the people who are unhappy with the result or the services come back and be saying, oh, but I need you. You were so good. And like, you didn't think that when we were representing you, or you weren't so happy with the results, and maybe this is not a good match this time around. So sometimes that happens as well.
I will add too that it's become part of VIP's practice to try to encourage clients to enter a pro se appearance at the end of the representation that a volunteer has done, if the volunteer is not necessarily inclined to continue on. But we also do encourage our clients to reach out to VIP too, rather than the volunteer directly, so that we can filter that kind of relationship, so that our softies don't have to feel bad if they want to say no or they're not available. They can tell us no, and then we can handle that on the back end.
Okay, so this is kind of digging more into the meat of custody cases. How do you prepare a client or manage their expectations going into their hearing? I think many of us have had an experience that your client is saying, I want this type of custody and that's all I will settle for. And being that you understand the law and maybe the judges in the court, you recognize that that might not be the most feasible thing and that might not be the likely outcome. So how do you temper those expectations and kind of talk with your client through their options and what can happen?
I think that you'll get better at that. A volunteer will get better at that the more experience they get, because managing client expectations is critical. Somebody comes in and they want sole physical custody of their daughter, and the other party's been involved regularly for years and there's no issue with that parent. You got to be able to tell the party that you're representing that, and point out the reasons why. And I would say most times you can manage that expectation. Sometimes you can't, but you'll get better at that as you get more experience, because you'll know what reasonable expectations are. You may know the law in the beginning, but so much of our practice is based on custom and knowing the judges and knowing kind of how facts are utilized by judges in making decisions.
And I always think you just have to be honest, and that's hard because if the client, like Lee gave a perfect example, if the client really isn't going to get anything, I think you have to tell them. And that's sometimes hard. And sometimes even now I find myself sort of having to work up to that. But at some point, you just have to take a deep breath and rip the Band-Aid off and just tell them, look, this is what's going to probably happen, or here's the range of options. What you want is probably not going to happen. And then you have to make a decision about whether you want to go for that or not. Because sometimes you still might want to go for it because you never know. Or sometimes you just may realize it's just a waste of time and money, and you have to be honest with the client about that. And I also always put it in writing and try to keep it as simple as possible. So I have the conversation. If I can do it face to face, sometimes that's easier. And then I do a letter saying I'm confirming X, Y, and Z. Here's what you wanted. Here's what I said. Here's what I think. And I just put it in, sometimes even like kind of like an outline form or a PowerPoint, just boom, boom, boom. So that it's very clear to them and I give them time to read that, and then we move on and prepare. And sometimes you can control that and manage the client's expectations, and sometimes they're just not going to hear you, and you just have to do the best you can.
I think this is one of those key places where, like, having a mentor if you're new to custody cases can become really, really important, because it's hard to know. I mean, of course, like, is it legally possible to ask for sole custody? Sure. Might that backfire in a million different ways in your case? Like, yeah, like A, you're like unlikely to get it. And B, one of the custody factors is, what is this parent going to do to encourage the relationship with the other parent? So it may actually, like, legally count against you if you go into court asking for sole custody. And so, you know, understanding the difference between, sure, like, that's a thing that can be asked for, versus how's this actually going to play out in the courtroom. I think that's where, like, the help of a mentor and thinking that through to be able to counsel the client, I think it's just critical, because you don't want to go. I mean, sure, right. Sometimes we take a chance and just go in and say, oh, well, we'll argue this and see if it sticks. But sometimes, you know, what the client is wanting to go in can actually, you know, and request can actually really harm them, and you need to be able to spot the difference and be able to counsel clients about the difference.
And don't be shy about, I mean, I know Lee's a big fan about this. He could speak to it easier than me, but don't be shy about getting and using the mentor. I never feel that I'm being bothered. Sometimes it helps me often too, because it's an interesting issue, or it's something new, or it's a challenge. But that's what helps you think, is when you can talk it out with someone else. So absolutely have a mentor through VIP. You may know other family law attorneys. You can talk to more than one person. But I think, you know, I think that's critical. I think Sarah and Lee are right. Like, that is critical, to have somebody you can bounce it off of. And we all do. I mean, all three of us have people that we bounce things off of, or several people that we call. So you need to do that, because that's how you're going to, one, learn, and also, you know, get an idea. Is this possible? Is this not possible? Or maybe even vent your frustration with your client, and the mentor can kind of say, okay, here's what you might want to do, and come up with something else. So absolutely use that.
I want to talk for a second, Lise, about mentors, because you know how I feel about
Yep.
them. I've been in this practice for 41 years. I have mentors. Unfortunately, my mentors are retiring because of their age. But the fact is that you should never be embarrassed to ask somebody else about a fact pattern or what's going on. That's what keeps me coming back in the office every day right now. It's just the new issues that we confront every day. And you not feeling confident to have a mentor, or being embarrassed because you don't know the answer. Nah. I have 3 other lawyers here in the office, 4 right now. And we spend the day talking about our cases and asking each other questions. That's just the way it works. So please contact VIP, get a mentor, and take advantage of it, because that's how we all learn. And this is a collaborative practice in a lot of ways.
Thank you for that response, everyone. I think, like you're saying, some newer attorneys that might want to foray into custody and other family law matters, and if that's not their normal practice area, they feel a little odd collaborating with others. But I think you hit the nail on the head, Lee, that this is a very collaborative area, and everyone is better off for talking things out with each other and getting everyone's opinion. Kind of in the same vein, beyond just mentorship, what resources do you feel are available to you, or that a new volunteer would have available to them for custody cases?
I think actually the work we've put into improve, you know, each year we update the custody materials for VIP volunteers, and I know a number of us have contributed to that, but that is a really great resource and a really good starting point, because it gives you sort of both the law as well as the process, like the real practice reality. So that is definitely a good first step. I also think, you know, to the extent, I don't know, there are a lot of forums on the website, or, sort of the common forms, but if there's something that's not there that you need, again, that's where mentors can come in, because I think all of us are happy to share whatever forms or examples of things that we've done that may not be the usual pleadings if they're not already there.
But I also think, I just think using the custody factors because they're statutory. And one thing, I guess this goes to preparing a client too, and the attorney, is I have them in, like I've typed them up, I have them in Word. And at the beginning of a custody case, I'll send them to the client. So just that's a resource, just the statute and looking over the statute and understanding what the court is going to be looking at. Some basic custody research, so you understand what best interests are, or if there's a particular factor issue in your case. Have there been decisions one way or another, like on that case? I think that's a resource. And I think Lee was talking earlier before we got on this, that somebody was watching a hearing. I mean, that's a resource too, is to contact somebody or contact the court and go sit into, for a couple hours, go sit into a hearing. Most judges will let you do that. I think we would be okay with it as long as everybody consents, so you could go that route too. But those are resources too, because that helps the skills and the thinking as well.
Okay, so pivoting back to questions about the actual hearing once you've taken your first case. How do you prepare with the client for their hearing?
I'll go.
Go
I'll
ahead.
jump in then. Yeah. So for me, the custody factors are key. So I send them to the client and I say, make one on each page and spend 2 or 3 weeks and write down everything you want me to know about each of those factors. And I also find that that's easier time-wise. One, I have it in writing, so I can just copy it into like my trial outline or how I'm talking to the client. And 2, I don't have to have that. It's easier for the client to do it that way. So I let them do it, and then I take the pages, and then I just sit down with a cup of tea or, and just read through. And that's actually how I might use, depending on the case, that's how I might start my trial outline. And then I tell them to add to it. And then, depending on what our time is. So I guide them that way. So that's, one way to start doing it.
Definitely grounding the custody factors and making sure you're going to hit. I mean, ultimately, right? The custody factors are that's your burden when you need to prepare your case. Another tool that I use is trying to get the client in their own words to explain their concerns about what the other side is asking for, to the extent we know that, right? And that often also then feeds right into my trial strategy. Like often that's, maybe the third question I'm going to ask in my direct is sort of, what are your concerns about either the current situation, right? If there's already an order in place, or if there's not an order in place, about what the other side is asking for, or what might happen if, your petition is not granted. Because it can really help. A lot of times we'll end up hitting the custody factors anyway and talking about those top concerns. But if we can narrow down, like my primary concerns are, the other side has, untreated mental health issues that they've, told me in the past they're diagnosed bipolar, but they're not taking their medication anymore. Or, I know there's substance abuse issues, or I know there's, some issues around the housing. I find it helpful to be able to kind of zero in on those and then build out from there, because we can, build in questions that again speak to the custody factors, but also you get limited time in these hearings. So you also need to kind of have a strategy as to how to get the judge's attention focused on the most important things. And so that can be sort of a tool both in the preparation, but it feeds right nicely into my trial strategy.
Also, just not to overcomplicate, but be aware that in addition to custody factors, there are relocation factors. So you just want to be aware of that. Relocation is when a parent wants to move out of the area, basically, with a child. And just be sure you're aware there's relocation factors, which you need to use as the structure of your case in that arena.
the other thing, I would just add on to something Sarah said. So initially, and you can do this in the way that Sarah's talking to the client and getting the information, talking to the client at the beginning of the case, and sitting down with them for an hour and a half, whatever, is also key because you learn how the client answers questions. So do they pay attention to the question that you're asking and answer that? Or do they just want to say what they want to say and they don't care what your question is or what the answer is? Because that's going to be key in how you prepare that client. Because if they can focus and they can answer, great, and you encourage that. If they're all over the place or they just want to say what they need to say, then you need to know that because you need to prepare them not to be like that. And you need to ask your questions at the trial and present your case in such a way that you don't give them as much wiggle room. And clients are, no matter how much you prepare, they're always going to say something or throw something out there that you didn't want them to, no matter what. So you kind of need to be flexible and prepared for that. But I always try to do that also at the beginning of the case, like sit down and talk to the client and get a sense of how are they going to be when I'm asking them questions, or the judge. And then I also have, I'm sure all of us do, a list of how to prepare them for the actual hearing. You know, what to do if somebody objects, what, you know, how to speak to the judge, how to react to opposing counsel, so that's also important in the preparation. That part's closer to the end. But the part about getting how they're going to respond, I think is key to get at the beginning. And that's also going to help you know how to manage the client's expectations moving forward, because you're going to get a sense of what they hear and don't hear.
Right. Thank you so much for tying that back to managing clients' expectations. I think that's a big concern for a lot of our volunteers, is just family law is so close to our clients' hearts that you don't want to let people down if you're not able to get them exactly what they're looking for. So in a similar vein, how do you go about debriefing with clients after their hearing has taken place? I know usually clients have questions, they might not have fully understood what just happened. How do you talk them through that?
I do a couple things. I mean, one, usually right when we come out of court, I say, let's sit down in an attorney room and have this conversation now, right? So you start right then and just make sure, like, okay, this is what was just ordered, and this is what you're going to need to do, particularly if there's follow-up. But I don't leave it at that. I also always write a letter post-court summarizing what happened, both summarizing what occurred as well as any next steps that need to happen. So and sometimes that's a closing letter if the litigation is done, right? It's also saying, and I'm going to be closing your file soon, but even if it's not closing, still doing that that letter. And then usually if there are sort of unclear things or things that were sort of left hanging, like sometimes there's need for a follow-up phone conversation or even meeting if there's, you know, particular things that they're going to have to navigate afterwards in order to do it. So that sort of depends on the case. But I always do the meeting immediately when we walk out of court, and I always write the letter.
Well, I do 1 out of 2. I don't write a letter because I'm not as organized as you are, Sarah. Generally, I'll sit down in the waiting area with the client and just chit chat for like 10 or 15 minutes. Just be sure they understand what happened. They understand what's still open, if anything. Talk about what, if there's going to be another hearing scheduled, whatever, you know, just kind of start planning for that. At the end of the case, I generally don't do withdrawals because I just don't think to do it. So that kind of keeps me in these cases. And then when a new petition comes up, sometimes I'll talk to the client and decide at that point in time whether I want to be in or not. But mine is just a conversation after the hearing.
All right. So now we're moving on to a few more VIP specific questions. So if any of our volunteers don't feel like they know the answer or want to answer, I think myself, Denise, or Cassidy can pop in. So what skills do you feel like are developed by taking custody cases?
I'm happy to take that. I mean, I think I think there are a variety of skills, right? So there's client interviewing and counseling. That's a big part of it. Sometimes there's drafting of pleadings or other types of legal documents. There can be negotiation, right? Particularly if you're trying to reach a settlement with the other side. And then there's, of course, just like in court trial skills, right? It's very much on your feet trial work, and both the prep that goes into that, as well as, the actual execution of doing the hearing. So I think it covers a lot of bases. And I think the reason that I jump in so quickly on that is because I teach in a law school context, like, often I'm having to talk about, well, what skills will you get from this? Because I'll have students who come in, some of them want to do family law, some of them want to do completely other things, but doing the family law clinic can be a good way to build the skills to get them to those other things. So it can be a good way to get into the courtroom. It can be a good way to build your client interviewing and counseling skills, even if you decide, well, the limits of my family law experience are going to be this one case. So
I think from the other side, from the client's perspective, I think the volunteers need to know that just by you being there next to them in the courtroom, you've changed the whole tenor of the hearing. Generally have a lot more control over what is presented, and that's important because many litigants don't know what to present. And when they go in unrepresented, they can start presenting things to the court that the judge it's irrelevant. The judge has no interest in hearing. And at least in our office, it's a very common complaint to get a call from a litigant who was unrepresented the day of or the day after hearing and say, I just was in a hearing in front of Judge X's courtroom and they wouldn't let me talk. And what that means is, I think that what they were talking about, what the client was talking about, was not really helpful to the court. And so they shut them down. And that's very unfair. But just by having a lawyer in the room, regardless of your experience, you've done a great service for the client because the whole tenor and pattern of the case is completely different. So just know that you being there is really a big portion of the battle for the client.
I think you also, and for me, I think you gain interpersonal skills. So like your EQ, your emotional quotient, your empathy, your patience. You develop all of that, I think, in any custody case. So not just a VIP case, but in any case. So, and I find for me, the trial stuff too, but for me, I think it challenges me more with the patients, or to take a deep breath and understand what the client is saying and guide them through it. So for me, that's an additional skill, not quote unquote a legal academic skill, but just as important in any family law case, but especially a custody case. And every client is different. So I'm constantly challenged by that, which is great.
Right. Similarly, we kind of touched on some of this, but how do you feel that taking on the cases actually impacts the client's lives? I know, Lee, you spoke a lot about the impact with the court and how you feel like there's more control and direction in their cases, but would anyone else like to chime in with how they feel it improves clients' lives to have an attorney there with them?
Well, I think I can't underscore enough the point that Lee made, which is I think like the mere act of standing up next to the client is actually something that I would argue is actually revolutionary, right? In terms of how much it changes the experience of going into court. So I think that in and of itself means everything, to have somebody there to stand up for you. I also have the thought that, like, when people feel they were heard, they buy into the result, whether they won or lost, whatever won or lost means, to them. And I think it can be hard to feel heard if you don't have the assistance of an attorney to kind of ask the right questions and bring out the right information. And particularly if it's an able attorney who's counseled you like, hey, this might be a reach, but we can try, but like, we can ask for A, but we might get B, and having that, that kind of clear game plan going in. I think can help a lot in terms of people feel like, well, I tried, I was heard, I told the judge what I needed to say. The judge ruled, I can accept this result. Obviously not for every person, but I do think that it makes a big difference if people feel like they were heard versus people feeling like they were shut down. We can't win every case. We try, but
So how do you feel like VIP's involvement with custody cases is working? Do you feel supported? Do you feel like, I know from the inside perspective that we send the case file and we touch base with clients about once a month. But do you feel supported, or like VIP is providing any resources or any assistance that you might need to carry the case to the end?
I mean, I have to say, I love taking VIP cases because they've already been vetted and prepped to some extent, right? I mean, some of the beginning work that we might otherwise need to do in-house has already actually been done. So for someone sitting, where I sit, where I'm putting students on these cases, it's actually easier, to take a VIP case and know that it's already been, there's already been some work put in, some gathering of documents, some information gathered, because we can kind of hit the ground running in a way that we don't always get to with other matters that come our way. I think the flip side of that, I at this point don't need as much support, although likely I think we all have mentors and we all have the people we turn to when we have questions. But being in the role of mentor, I feel like that can be as involved or as not involved as the person wants it to be. So it can be many, many conversations about your case, or one conversation about your case. But I think that's the unique thing that VIP has to offer for people during taking cases.
I think that question is really better directed to the volunteers that are here listening to us gab. Do they feel supported? Do they feel like the resources that VIP has is helpful to them? I mean, that's the best person to answer if anybody wants to.
So I would be happy to answer that. And I felt extremely supported last week, just before I took my first custody case. I will share that I started with the manual that is posted online in the Philadelphia VIP's website. I continued to dig into the facts of the case, to interview the clients at the VIP's offices. And then I spoke to Lee, as well as with Susan. And also the 2 full days that I sat at Judge Ford's courtroom was extremely helpful. For me, it was very important to feel the atmosphere of the court, to see how the judge is actually handling the case. How much weight does she give to represented parties? And generally, I think that the bulk of the cases were parties that were unrepresented, but in those cases that parties were presented, so it seemed to me that the counsels was there just to have their clients sit down and not interrupt and stuff like that, because the actual hearing was between the parties and the judge. That was at least from my impression from those 2 days. And again, there was very little cases where both parties were represented. So I had a lot of resources, a lot of help. And it was, everything together was very helpful and very beneficial to end up in a successful case and with a happy client, of course.
Right. And thank you for sharing your experience, Lee. I know, as Denise mentioned at the beginning of this Q&A, she is one of our newest family law volunteers, and it's really lovely getting to meet new volunteer attorneys who take an interest, because as we all know, family law is not necessarily anyone's first choice unless you're crazy like us. And it's really lovely when you meet people who are excited and willing to learn about the area. So my final question is, what information do you find is most important to provide VIP at the end of your representation? I know that we like to get info like on the custody order that was granted or how many hours you spent, but is there anything that our panelists feel that we should be asking information on when you complete a hearing? Is there anything that we could be taking in to improve our system?
I often unsolicited provide information about how happy or unhappy the client was with the result, right? Or whether there were any problems or sort of hiccups in the attorney-client relationship, right? Like, because I think it's helpful to VIP to know, like, hey, this person was really angry with us at the result. And we, despite telling them all along this wouldn't, likely result in the thing they were asking for, they really were, pleased, or this person was incredibly grateful and can't stop thanking us, or everything in between. Often it's highlighted in our closing letter, but if there are sort of follow-up points like, hey, before they go back to court they're going to need to do X or Y, I'd like to have that, because often, sometimes the call will come back to us, but obviously sometimes the call is going to come back to VIP if there's future issues. And so I'd like to be able to provide that sort of individualized insight to the extent it's needed.
All righty, so that concludes our prepared questions for the Q&A. Does anyone here have any additional questions that they thought of while we were talking?
I actually had, if I may.
Go ahead.
So I actually had 3 questions. The one is about the technicalities of filings. Is there any electronic filings at all with family court, or for everything do you actually need to go and stand the very long line in the 11th floor?
No, nothing is electronic.
Online.
0. You can do some things by mail. So you can either go in person, which I tend to do more, but not always. There is an attorney line. So sometimes when somebody's there and staffing it, that actually does make a difference. Sometimes you can go and stand in line and file and see how long it might take to get it processed and just say, okay, I'm going to come back. You could go do some shopping or I've done it where I've gone to court actually, where I've gotten in early and then run up and done my case and then come back down to pick it up. So that helps. And some things you can do by mail. It really depends on, the importance of the case and how soon you need something back. But I do that sometimes. I also try to organize my filing and so that I can take it all down at one time. But no, can't file electronically. In Philadelphia, other counties you can, but not in Philadelphia.
Okay, thank you. And then my other question was, I am considering taking another case with the VIP, that is PFA, and I wanted to know if you have any tips or suggestions about how to prepare towards a PFA hearing.
I'm happy to talk offline about PFA cases as well, or even the specifics of a PFA case. I think in a way PFAs are much more straightforward because there's a very clear standard. There's a definition of abuse and either it's been met or it hasn't, right? So there's a fairly clear threshold. And I think, depending on which side of the PFA you're on, right? At least you have the standard and you're trying to figure out either how am I going to meet my burden to meet the standard, or how am I going to show that the standard's not being met? So in a way, they're more orderly trials. Then custody can feel a little bit more like a ping pong match sometimes, but more sort of formal and traditional trials if it goes to trial. So I think I'll stop there, but I'm also happy to have a conversation about PFA practice elsewhere.
There's also under the statute, there's specific conduct that constitutes abuse. So you have the standard of what degree of conduct is abuse. And then you have the number of different events that are abuse. So people will often file petitions because of psychological abuse or because of financial abuse. They're not abuse. And you really need to sit down with the statute. It's not difficult. It's very clear. And just read the type of conduct that is abuse and go over it with the client. And if it's not in that, it's like round peg, round hole. And if it's not one of that style of conduct, then it's probably not abuse. You have to let them know. You can also try and work out an agreement in PFA, where instead of going for the 3-year full PFA, maybe you go for a lesser period of time as a compromise. So and Sarah, like Sarah's offered to talk, I will too, so will Lise. But again, as Lee did, if you can get into a courtroom for a half a day and just sit and watch a judge and watch some cases, you'll kind of get the flow.
Great. Thank you for that. And like Lee said, I can connect you everyone offline after the Zoom ends, so that if Lee has additional questions about PFA, she has the experts at her fingertips to ask. Does anyone have any additional questions regarding custody?
My last question was, under what circumstances a court will grant sole legal except for when a parent is incarcerated, if at all?
It's a super fact specific, so I think the real answer is the lawyerly, it depends, right? Because it's a super fact specific inquiry. I think the times that I have successfully requested and been granted sole legal often happen where a parent is sort of actively standing in the way of decisions being made for the child, or actively making decisions that are not in the best interest of the child, right? So if you have one party who really is interfering with the child getting medically recommended medication or a surgery, or things like that, it can happen. It's relatively rare. And to be honest, there's not case law that says, just because you're incarcerated, you can't share legal custody, right? So you still have to show that the parent is either sort of not making themselves available to make these decisions, right? Or is actively interfering in some way, such that, the case law does talk about minimal level of cooperation, right? So it doesn't mean you always agree. It's just, so I think a lot of it's going to come down to specifics of the case.
Thank you.
Yeah, I think there's more. I absolutely 100% think Sarah hit that. I think there's a few more cases recently because of the vaccination issues. So there's a little, and I'm not sure if there's been any appellate decisions, maybe one recently. So there's some cases on the common pleas level. So at least it gives you an idea of what the standard might be or what judges might be looking at. But I absolutely agree with Sarah. It is so fact specific. And remember, it's the best interest of the child. So you have to show that something did, or like Sarah said, did or didn't happen. And what's the effect on the child of that? So there are definitely a few more cases within the last year or so that you can read to get a sense, but it's still going to be fact specific.
Thank you. Do you mind to refer me to those cases?
You know what? Call me offline and I will find them. I think I've actually been saving them on my computer. So
okay,
reach out to me online and I'll email them over.
All right. Thank you.
Yep, absolutely.
Okay, I think we are just about out of time. Thank you to our lovely panelists for joining us this afternoon. This was really great. And I think, we're recording this, and I don't know, Denise, if we're going to post it on the website, but I think this really hits the nail on the head of a lot of the questions that new custody volunteers are wondering, and the things that are maybe standing in the way of them accepting their first case. So I think our panelists put everyone's mind at ease that you can do this. Custody is not as scary as everyone thinks it is. And as you mentioned, we have the resources and the mentors available that you will be supported by taking these cases. So thank you for everyone for joining us, and have a great day.
Thank you.
Thank you.
Take
Bye,
care.
everybody.
Bye,
I'm just gonna
everybody.
add, if anybody has questions, feel free to email us. I will reach out again. Have a good one, everybody.
All right. Bye-bye.